jury, from your experience in other cases upon which you have sat, you have no doubt had a fairly clear idea of your duties and responsibilities. You know that you are bound to take the law from the court and follow the court's instructions without question. On the other hand, you are the sole and exclusive judges of the facts and of the credibility of the witnesses. By credibility of witnesses is meant simply that it is not for you to say what witnesses you will believe and what witnesses you will not believe. In determining that question, take into consideration the interest, if any, which the witness has in the case, his motive for testifying, his appearance on the stand, and his intelligence, and after applying your own experience as practical men of affairs, make up your own minds where the truth lies. You will scrutinize with care the testimony of an interested witness, and if you believe that such a witness, because of such interest, has testified falsely or colored his testimony, you have a right, if you choose, to disregard the entire testimony of such a witness. Of course, bear in mind that an interested witness may be just as truthful as a disinterested witness. So too, if you believe that a witness has willfully testified falsely as to a material fact, you have a right to disregard all the testimony of such a witness, and you must disregard the testimony which you think is false. The plaintiff sues here upon a promissory note claimed to have been made by the defendant. The amount of the note is $2,500. It was made payable to the defendant's own order and endorsed by the defendant. The plaintiff claims that he is the lawful owner and holder of the note, that he gave value for it, and that he is a holder in due course, and that he is entitled to recover. It is not disputed by the defendant that the note in question was made, nor that it was endorsed by him. It is claimed, however, that the plaintiff here is not the true and lawful owner of the note, or that he gave consideration for it. It is claimed by the defendant that this note was made and delivered upon the express condition and understanding that it was not to be used as collateral or for any other purpose until a certain bill pending in the state legislature, and in which certain members of the municipal police force were interested, had passed and had been enacted into law. The defendant claims that the plaintiff had knowledge of the conditions upon which this note was made and delivered, and that while the plaintiff did not deal directly with the defendant at the time he made the note, he is still in no better position so far as recovering upon this note is concerned than those who did deal directly with the defendant. I shall now charge you as to the rules of law that are applicable to this situation and which control his legal rights of the parties. Now, failure of consideration is a good defense in an action on a note as between the original parties. The original parties here, for the purpose of this case, are the defendant and Officer Jones. It is not claimed that Officer Jones gave any consideration for the note, that is, that he parted with anything of value when he secured the note from the defendant, and if he were suing here, he could not recover on this note. Failure of consideration is not, however, a defense to an action on a note brought by a holder in due course, and if this plaintiff was a holder in due course, he is entitled to recover on the note, notwithstanding that Officer Jones, to whom the defendant originally delivered it, could not recover. It therefore becomes important to determine whether or not the plaintiff is a holder in due course, or whether, by reason of certain facts claimed by the defendant to exist, the plaintiff is in any better position than Officer Jones. Before taking up for consideration the question of what constitutes a holder in due course, I will charge you what effect, in law, the mere presentation by the plaintiff of the note in question has upon the legal rights of the parties. I charge you that the production by the plaintiff of the note in question constituted prima facie evidence of the plaintiff's ownership, and further, that in the production of this note so made and endorsed by the defendant, a consideration is presumed, and that the burden of proving a lack of consideration is upon the defendant. So, you will observe that the court has held that the plaintiff has made out a prima facie case upon the presentation of the note and its introduction in evidence, and if no further evidence has been introduced in the case, it would have been incumbent upon the court to have directed a verdict for the defendant. As already appears, the defendant alleges that the plaintiff was not a holder in due course because he had knowledge of lack of consideration and the conditions upon which the note was made and delivered. The question is, what is a holder in due course? What are the rights of such a holder? It is provided in the negotiable instruments law in section 98 as follows. Every holder is deemed prima facie to be a holder in due course. But when it is shown that the title of any person who has negotiated the instrument was defective, the burden on the holder to prove that he or someone under whom he claims he acquired the title was a holder in due course. How's it?
Good.